In this case, the alleged offense took place at a B club on the dawn of 17th of January 2020. The prosecution lined up several witnesses who were in the club in support of its case. These witnesses included security officers at the club, some patrons who were drinking in the club with the accused person, and the waiter who was serving the accused in the club. None of these witnesses, however, testified of any of the above elements of disorderly conduct on the part of the accused person while at the club. The only evidence touching on the conduct of the accused person that evening was from the investigating officer, who was not at the scene. He stated that he arrived at the conclusion that the accused person conducted himself in a disorderly manner by a review of CCTV footage that was played in court of what transpired at the scene, and stated that the accused person was seen arguing with Felix Orinda, and that then the accused fired his gun and shot Felix, who fell down. These facts were disputed by the defense, who stated that there was no such argument between the accused and Felix, and that the accused did not shoot Felix. They called the accused himself, the victim, who stated in his evidence that there was no such argument. The law places an obligation upon the prosecution to prove each and every element of an offense beyond reasonable doubt. The mere fact that the accused admitted to having carried his gun to the entrance of the club and having had gunshots on the night in question does not absolve the prosecution from this legal burden of proof. In this case, in order to prove actus reus of the offense, that is the act of shooting the victim, as against the accused, the prosecution must prove, firstly, that the victim was shot and wounded by a firearm. Secondly, proof must be tendered of the type of firearm and ammunition the accused had. And lastly, proof must be tendered that it was a shot fired from the accused's firearm which shot the victim. My view is that the prosecution did a woeful, shoddy job in regard to this when it comes to proof of the foregoing. To begin with, it was stated that the victim sustained gunshot wounds and was taken to Nairobi Hospital. However, inexplicably, there was no medical evidence that was tendered by the prosecution to show what injuries the victim sustained and the cause of those injuries. The investigating officer appeared to have been relying on the CCTV footage, but in my view, the images on a CCTV footage or statement by the victim that he was shot cannot be substitute for medical evidence. The primary evidence that ought to have been produced to prove the victim was shot by a gun was the medical report or a duly filled P3 form to confirm that the victim had suffered a gunshot wound. The said victim, however, turned out to be a key witness for the defense. In his testimony, he testified that before the incident, he was talking with the accused and did not see him with a gun. He also stated that he had no squabbles with him and that they did not quarrel. He stated that he suddenly had a gunshot which hit him, but could not tell from where it was fired. He, however, stated that he was told that the accused took him to hospital. The evidence of the victim therefore discredited that of the investigating officer. Having failed to adduce evidence that the victim was injured by a bullet wound, the next question then is, whether the ballistic expert report links the accused person to the offense. It is noted that the prosecution alleges that a bullet head and a spent cartridge were recovered from the scene. The investigating officer stated that he was not the one who recovered them and could not recall who recovered them. He, however, stated that the bullet head was recovered from a wall at the scene. He did not state the location of the wall from where the bullet head was recovered and the distance from where the victim was lying. My question would be, why did the investigating officer not avail the person who recovered the bullet head and cartridge in court to testify? Was it not necessary to confirm that they were found at the scene where the alleged incident happened and confirm that they were from the accused firearm? If the bullet head was recovered on the wall as claimed, was it not necessary for the ballistic expert to visit the scene and adduce evidence on the possible trajectory from the point where the victim was shot? Was it not necessary to avail medical evidence to show that once the victim was shot, the bullet actually exited from the body of the victim and could have landed on the wall as claimed? Having seen the CCTV footage, was it not necessary to avail evidence to show that from the angle the accused was standing, it was possible to recover the bullet from the wall where it was allegedly recovered? These, to me, are important questions which ought to have been considered and addressed by the investigating officer during investigations. And this is where I reiterate that the investigations herein were shoddy, as very crucial areas were not covered. It cannot also be denied that bullet wounds can provide some information about the type of firearm used, caliber, bullet type, and trajectory after the incidents. And the investigating officer ought to have availed this evidence. In his testimony, the investigating officer testified that the recovered bullet head and the cartridge, together with the accused firearm, a pistol serial number 3159039, a magazine and 9 rounds of ammunition, were forwarded to the ballistic expert for analysis. PW8 is a ballistic officer and testified in respect of the examination and analysis he conducted on the exhibits mentioned above. He stated that he examined the exhibits and confirmed that the exhibit marked A and exhibits marked C1 to C9 were firearm and ammunition, respectively, and were capable of firing and being fired. He also stated that the ammunition were caliber 9 by 19 millimeters. He also formed the opinion upon analysis of the recovered spent cartridges case that it was found to be in caliber 9 by 19 millimeters and had sufficient breeze face markings, ejector markings, and firing pin identification, which enabled him form an opinion that it was fired from a Mannlicher pistol, like that one of the accused person. In regard to the recovered bullet head, he stated that upon examination, it bore 6 identifiable land engraved areas similar to those found in the accused's gun. He, however, stated on cross-examination that he could not tell whether the recovered bullet head and cartridge case were related. He could also not tell whether the bullet head that was recovered and marked E was shot from the accused's gun. He admitted on further cross-examination that there were many firearms which could use a 9x19mm ammunition, like Seska pistols, Glock pistols, Smith and Wesson, etc. The net effect of the evidence of the ballistic officer's evidence was that though the accused's firearm may have been used to fire the recovered cartridge and recovered bullet, there was a possibility of other firearms doing the same, and therefore could not conclusively find that the accused's gun could have, was one that fired the recovered bullet head and the cartridge. It was upon the investigating officer, therefore, to avail collaborative evidence, as the evidence by the ballistic officer could not stand on its own. Having evaluated the evidence available before me and applying the relevant test, it is my finding that the prosecution has not proved its case beyond reasonable doubt. He point out the following factors for the so finding. One, that there was no evidence presented to show that the state of sobriety or otherwise of the accused in the allegation of being disorderly. The victim, two, the victim of the alleged offense denied that he quarreled with the accused and that the accused shot him. C, no medical evidence was presented to show that the accused person, the victim, had been injured by a gunshot. And finally, the ballistic expert did not conclusively find that the accused's firearm was the one used in the act. For the above stated reasons, the accused is found not guilty and is acquitted under Section 215 CPC. And in conclusion, the court notes that this is a case of great public interest that may have gone wrong during investigations, and perhaps the DCI should consider such cases being investigated in future by senior experienced officers, at least in the rank of Inspector of Police and above. So that is the judgment of the court.